topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Experts show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Good afternoon. Welcome to another Ask the Experts. We are so excited today because today is K. Bender Rimbaum Day. Let me tell you something. They are now growing faster than we are. They are in South Florida. They're in Palm Beach. They're in Orlando. They're in Tampa. And they are community association law firm, one of the finest in the state of Florida. And we are lucky to have one of their attorneys who's going to answer your questions today. We are going to educate you. So we want you to sit back, take notes, and let me introduce you to Attorney Alan Swartzide. Good afternoon, Alan.
Afternoon, Steve. Thanks for having me. And I just want to clarify for everyone, lawyers don't answer questions. We don't give yeses or nos. We just say, well, it could be this or it could be that. So you can expect a lot of that today.
Well, listen, we get so many letters, people complimenting you on how you answer questions. If we've got several ways that you can ask questions. You can call in at 561-623-9429. If you're watching on our TV version, we actually have a screen where a lot of people are now asking questions on the screen. Or you can call us at 954-336-3767 and text us your questions. And we get text for an entire month, which we will be asking Alan. We've got so many great questions today. But before we go to questions, Alan, tell us about K. Bender Rimbaum.
Sure, I'd be happy to. So I think you already mentioned we've got offices in several locations in Florida. We do practice statewide. We've got 20 attorneys in the firm, 8 of whom are board certified in community association law, which means that they are considered board certified by the Florida Bar in representing or dealing with condos, HOAs, cooperatives, etc. Those are really our only clients. There are very, very, very few instances where we represent anyone else, and it's been that way since the 1990s. This is all we do is give legal advice to community associations, and we think that the education portion, which includes being with you here today, Steve, and again on I believe Thursday of this week, educational programs like the board certification class I taught earlier today. So if I lose my voice at some point, I apologize. That's because I've already been speaking for 3 hours straight today. But bottom line, we think education and quality customer service are two of the most important things in this industry. And so anyone that's working with our firm is going to get a response. It may not be, the answer to the question, but we're going to at least acknowledge that you've reached out to us within 24 hours every single time. Now, let me qualify that just a little bit. That applies to clients and potential clients. We may need to get answers from our client if it's, let's call them the other side. So, but the 24 hours every single time is something that I strive for, and I have not disappointed anyone yet when it comes to at least that.
That's really important, especially when a client has a question and they need you to help them as their law firm. I've actually gone many a times to your Pompano location, and there's always three young ladies there working the desk, and customer service is it's so obvious that's important to K Bender Rimbaum just by having those three women up there at the front desk.
Yeah, well, I mean, again, customer service and education are really things that I know that most of us pride ourselves on within the firm. But, obviously, good legal advice is pretty important as well. But let's be realistic. Everyone's going to say that you can get that from them. I think that the educational and customer service components are things that, in my experience and working with and against other law firms in this practice area, you just won't find elsewhere.
You've got a lot of classes coming up, which we are now scrolling, which usually about halfway through the show, we will actually talk about those classes for people who are on radio and can't read it. I've got all the classes here. I don't know if you've got the classes also, but those classes are really important and free.
Correct. And keep in mind also, it's not just the ones that are coming up, and the ones that are being displayed on the bottom of the screen are not the only ones coming up. We haven't even set up a lot of our August schedule yet. But I think it's almost more important to mention that we've also got all of the recorded classes we've done over the last, I think Jeff mentioned there's about 150 of them up on our website right now. If you go to kbrlegal.com, and go to the resources tab, between that, Rembaum's Roundup, which is an email that is constantly updated every couple weeks with crucial information, timely information about what's going on in the industry. And then Robert K's Legal Morsels are also, just a wealth of information. Frankly, if I don't know the answer to something, the first place I research isn't Westlaw. It's on our website.
That's a very great compliment. Again, if you'd like to call in and ask Alan a question, number here is 561-623-9429. I guess let's get to the questions. We're going to start off with Mike in Tampa. He says, I'm losing one member of a 5-member board. One board member suggests that only 3 members vote, and the 4th member is used as a tiebreaker. I think this is wrong. What is your opinion?
So I mentioned earlier, I'm not going to give opinions. I was joking, and my opinion is that, Mike, you are correct that individual is wrong. There's no reason that you need to have that individual or one individual choose not to vote. There are 2 different options here. One is if you've got another person that's willing to step in on the board, you have another person appointed so that you have a 5-member board again. And so you're sitting there without a problem all of a sudden. You've got an uneven amount so that there is no tiebreaker. If you can't find somebody else to step in to that role, then you have the 4 people try and vote. If you end up in a tie, unfortunately, that's just the way it works. And you might be deadlocked for a while until you find that 5th member. You can either hold another election, or you can just appoint someone if you know of someone that's willing to serve on the board. So I don't think the right course of action is to ignore one individual's vote who was presumably voted onto the board for the purpose of voting at board meetings. I don't think that's the right course of action at all. And I think that it basically relegates that individual to a semi-board member, which doesn't exist. Steve?
Well, listen, we are getting inundated by people writing, and I love that. It's perfect for the show. We're going to go to Susan first. She wants to know, should the board attorney put his opinions in writing? Our attorney will not agree to put his opinions in writing. Speaking of opinions, Alan, what can we do?
Well, I mean, you can always use another attorney that is willing to do that. And frankly, someone that's not willing to put any opinion in writing sounds like someone who is not willing to stick by their opinions. Now, there are definitely circumstances where I'm going to call you and say, hey, you know what? I think that this is something that's better discussed verbally to protect the association so that this written opinion never gets out, because I think what you're doing is wrong and I want to correct you before it becomes an issue. Something like that. Yeah, I might not immediately put in writing, but I've never come across a situation where a client asked for me to put the opinion that they are paying for in writing, and my answer is, nah, not going to do that. So frankly, if your attorney is unwilling to put any opinions in writing, I mean, 90% of the time, my position is if it's not in writing, you got to act like it never happened. So yes, I gave you that opinion, but I would much rather follow up 5 minutes later with a brief email explaining what we discussed so that later on it is clear what opinion I gave. I don't understand the perspective of saying I won't put any opinions in writing. So again, I mean, I think my best advice that I can give is frankly non-legal advice to find another attorney. And if you'd like to reach out to me, my email is as@kvrlegal.com, because that is not an issue that you would have, I think, with any attorney at our firm.
This kind of brings up something. We just discovered a couple days ago, Alan, that there's about 10 phone numbers, which means 10 people that usually call into the show. Their numbers have been, for some reason, blocked. And their email, not by us either, and their emails have gone to spam. And one of those numbers has just come up. It's nothing that we did. I wouldn't even know how to do that. But this is from Barry, which we know very well. Great listener. Assume a majority of all unit owners of a condo waivers their pooled SIRS reserves for the 2025 budget year. When will their next SIRS need to be prepared by?
And Barry's usually pretty on point with these questions, but this one I'm not sure I understand, because we're talking about two separate concepts. Preparing your pooled reserves and figuring out what that number is going to look like is one concept. It's a budgeting issue. And when you're talking about when is their next SIRS required, that's to actually perform the structural integrity reserve study. So that's having an engineer, an architect, someone else who is authorized under Florida law to go out and perform a study of your condo building, having them do that. I just can't answer the question because I'm not sure how those things are supposed to mesh together. Presuming that Barry's asking, when do you need to fully fund the reserves because they're waived for your budget year 2025, my understanding is that you might be able to do that without getting in trouble and fully fund in 2026. But generally speaking, waiving the SIRS reserves is not something that's going to be allowed.
Barry's probably one of our best callers, and we're going to work and get that fixed, Barry. Let me go back to Eric in Orlando. Is there ever a requirement in a condo association where the board alone has to have a unanimous vote in order to pass, such as making new rules?
No, I mean, it's unless your governing documents are very oddly worded, it's always going to be a majority of the board. The only super majority of the board that I'm aware of offhand that's required is if you have a conflict of interest and one of the directors is trying to basically enter into a contract directly with the association, or one of his family members, her family members, or one of that board members' friends or something like that. There's a perceived conflict. That's going to generally require a supermajority, 2/3 vote of all other members of the board. But I'm not aware of anything, unless your governing documents, like I said, are very oddly worded, that would require a unanimous vote of the board. There are certain things that require a unanimous vote of the members, or might require a unanimous vote of the members. But when you're talking about the board, which is just your elected officials, so to speak, for the corporation, I'm not aware of anything that would require a unanimous decision.
Let's go to Michelle in St. Petersburg. Our community still does not have the audit for 2022. We were told the property manager didn't provide all the info needed. Is there anything the owner can do to push this along?
Well, when you say the owner, that depends whether that owner is also a director that's authorized to interact directly with the management company and push them along. Because if the answer is no, the owner should be reaching out to the board and saying, we needed to do this. If the answer is yes, that's someone that's on the board that is, authorized to interact with the management company, then they should be pushing the management company to get all the rest of the documents over to the individual or the company that performed the audit. And if management refuses to do that, then you should be involving the association's attorney in getting management to comply with what is generally going to be its contractual obligation under the management agreement to get all of those documents that are required. Presumably that's all of your official records, if we're talking about an actual audit, over to the auditor. If they're not willing to do that, then that might be a breach of the contract. It might just be something that needs to be dealt with. But if the directors have said, the auditor said they don't have everything they need, please get it to them, and given a list of what's needed, you need to involve your attorney.
So, Alan, we have gotten a lot of mail about homeowners insurance. And I mean, a lot. People are really, really scared. Several of the letters we got talked about insurance companies can purchase reinsurance to cover themselves.
Yeah, it's basically insurance against insurance. And of course, they're able to do that. So now they will. And unfortunately, what's going to happen is they're going to pass the cost of that reinsurance along to the people that are paying the insurance. So it continues going up and up and up. The legislature claims that their intent in passing some of these insurance-related bills this past year was to benefit the state, and that eventually they think that it'll help us and result in lower insurance rates. But you saw that there was another insurer that has now left the state just within the last 2 weeks. So the likelihood that that's going to result in lower interest rates is non-existent. So bottom line, all this is really doing is increasing the amount that everyone's going to have to pay for insurance while protecting the insurance companies themselves, or allowing the insurance companies to pay to protect themselves more accurately.
Do you hear anything coming up in the legislature that's going to help people with this?
Nope. Unfortunately, it seemed when this insurance-related legislation passed last time that they just have a really good, expensive lobby and are very successful. So I don't know that any non-insurance lobby is going to be able to guarantee, unless the government starts funding some of the insurance needs of homeowners. I just don't see it getting any better anytime soon, unfortunately.
Well, I gotta tell you, because this is not a political show at all, but people are very upset that our governor isn't doing something about this, and instead he's out, canvassing for presidency.
Well, I mean, keep in mind also that the governor doesn't always propose legislation. He, or if it was a woman, she gets to veto it or sign it in or ignore it until it gets passed. And unless there is a legislator that's going to do something about this, the governor can sign an executive order, but keep in mind, you've got, and I am no governmental expert. I represent community associations, and I don't claim to know very much else about the law. But the bottom line is, I don't know offhand whether the governor would have the authority to enter any kind of executive order that requires insurance companies to do anything. The governor,
very sad. So many letters, because
no.
There's a lot of people who are on a fixed income, and because we hear about other fees that are going up within the condo association,
right?
And but everything is going up. I mean,
Well, it's everything is going up due to inflation in general, but I agree, especially when we talk about the reserves that Barry brought up, which, I certainly understand it's his pet project. Unfortunately for all of us, it's kind of mine too. I know Allison Hertz of our firm is actively involved in the condo committee of the Florida Bar, but also in working on better legislation regarding, we had Senate Bill 4D this year. It was 154, but all the changes related to the Surfside building collapse and what condos need to now reserve, the reserve studies that Barry mentioned and I mentioned earlier. All of that is going to increase assessments. Regardless of how you fund it, it's going to cost the members more money. And frankly, one of the things that I am co-speaking about, I guess I'm a co-lecturer is the appropriate term, during this year's Condominium Institute in South Florida is what we anticipate being a reserve crisis unless the legislature does something or the government does something to help associations fund these things easier. Because if you can't get a loan because your governing documents say that you need member approval and the members won't approve it, then how are you supposed to fund this stuff outside of huge increases in your regular assessments or a special assessment that, like you said, you've got individuals who are on a fixed income and can't afford those types of increases. It's just a frightening prospect what we're going to be dealing with in the next year or two unless the legislation is cleaned up in this respect, and I just don't see it happening.
Okay, let's go to the board. Let's go to Linda. We live in a mobile home park cooperative and have no building 3 stories or higher. Okay, are we required to fully fund reserves in 225 and beyond?
So
we don't get very many questions about mobile park cooperatives at all.
Well, so the question then becomes what portion of the building is actually run by a mobile home park under Chapter 723 of the statutes versus being run under a co-op form of governance under Chapter 719. If we're talking about a co-op, okay, yeah, we might be talking about milestone inspections, SIRS, and those types of reserves. There's nothing that was changed in the mobile home park statutes that would make you need to fully fund reserves. So if those buildings are actually covered by the mobile home park form of ownership and governance, then chances are, no, you're not going to end up with any obligation to fully fund reserves because the statutes don't require it unless your governing documents do. If you're in a co-op, then it's questionable. I don't think that you'll have what we're talking about because most of the reserves that you need to fully fund under the statute are those specialty reserves that talk about the structure of a building and things of that nature. I don't think you're going to have any of those items that need to be reserved for. So if you don't have those assets, you might still need to get one of those studies done, but you might get something in that study that says, well, you know what? You don't have anything to reserve, so your reserve amount is 0. It's pretty easy to fully fund a $0 reserve. So that is the best answer I can give. Chances are, if you're talking about a mobile home co-op community, you're probably not going to need to fully fund anything because there's no structure that really needs to be properly reserved. Now, keep in mind, let me clarify that statement. You might still have to fully fund any reserves that are for the roads and other things of that nature, but you'll have a better opportunity as a group of members to vote to waive that full funding. The budget still needs to include full funding. The members just have an easier way of voting to say, we don't want to put all that money into our roads, which you can't do as of that effective date with respect to those SIRS reserves, the SIRS reserves, which are structural. Sorry, go ahead, Steve.
We're going to go to break right now. Before we go to break, give everybody, you have one number that's good for all 4 locations.
We do. It's 954-928-0680. That'll reach any of the attorneys, paralegals, or other staff in the entire firm. That's going to ring directly to those individuals that Steve mentioned being so kind when we were first starting to introduce the firm.
And the firm is K. Bender Rimbaum, Community Association Law. This is their day. We are answering your questions. We're going to go to break. We'll be right back.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. This is the Ask the Expert show. This is our 10th year moving around, and our expert today, K. Bender Rimbaum, has been with us for 8 of those 10 years, and we are so really blessed to have them and to have Alan answer your questions today.
Thanks.
Let's go to Skip in Tampa. Are poll votes by email allowed by HOA board members and then subsequently ratified in the next monthly board meeting?
So absent an emergency, you really shouldn't be using anything other than a board meeting to make board decisions. And there is a statute that specifically says directors can communicate via email, but can't vote via email. So that type of polling, to treat that as the vote, is really not something that an association should be doing, regardless of whether you ratify later on, unless you are in a true emergency situation and just don't have the ability to have a real vote. And let's be realistic. How many situations are so crucial and need to be so addressed in such a time-sensitive manner that you can't post notice and provide 48 hours notice and have a board meeting? There aren't very many. The other thing that I'll point out that a lot of people don't seem to understand is that community associations are not-for-profit corporations as well. And so they're subject to Chapter 617 of the Florida statutes, which in turn allows you to use a written resolution in lieu of a board meeting if the decision is unanimous and your articles of incorporation don't say you can't do that. So my suggestion, if you're sitting here and saying, oh my goodness, we have to get this done, at least do something that is treated as the equivalent of a board meeting and doesn't expressly violate the Florida statutes by voting via email. Have this document prepared by your attorney that is basically a resolution that all of the board members sign, and then you've got your vote just like you would at a board meeting. It's just without the members having the opportunity to be present and hear the discussion going on.
Here's Marvin in Clearwater. Our board of directors refuses to have meetings on site as we did before COVID. They want us to do Zoom. Many owners don't want to, or they don't know how to use Zoom. Also, refuse to speak English. Is that legal?
So every member has the right to attend board meetings. I would think that would include the right to attend in a way that they are physically capable of attending. If you tell me you don't know how to use Zoom and the association is not providing a step-by-step tutorial and basically signing up for an account for you if that's needed in order to log in. I don't think, in my own opinion, I'm not saying this is the opinion of the firm or any other lawyer, but I wouldn't think that that would be sufficient to provide an opportunity for those, I don't know if they're elderly or just technologically less inclined, for those individuals to actually attend the meeting. My other concern is if you're entitled to hear as a member of the community everything that's being discussed, then discussing all of the board decisions and having the vote held in a language other than the official language of this country, which is English, I presume at least, might pose a problem in basically treating anyone that doesn't speak that language as not being allowed to attend the meeting without an interpreter. It's supposed to go the other way around. If you don't speak the language, then you can get the interpreter yourself, and everyone at the meeting is speaking in English. I haven't seen any case law on this issue. I have a feeling a judge would agree with what I've just said, but that's no guarantee.
Alan, I see a lot of older, mature adults, and the technology really scares them. I mean, things that we just take for granted, just using a cell phone, scares them. So I can understand about the Zoom. I mean, Zoom is easy, but to them, I mean, sometimes it's hard for us to think how they think, and we forget that.
Well, I mean, if I'm in court explaining this to a judge on behalf of one of the owners, I'm pointing to my 95-year-old grandfather who doesn't speak, let's say the language, I don't think it was specified, but let's say it's French. Okay?
Okay.
He doesn't speak French. So what you're telling my grandfather is he can't attend in person, and even if he could, he wouldn't understand what the heck is being said. That is not allowing him to attend as intended and expressly required by the Florida statutes. At least, again, that's my opinion. And that's how I present it to a judge. I could see a judge siding with the owners on this issue and saying you need to have all of these meetings held in person, even if all you do is have the manager attend the meeting in person and have a computer sitting there with a camera so that everyone can see the director's faces on that computer, and you're not requiring everyone else to physically get onto Zoom. And then again, maybe they offer a translator that the association pays for, translating into English. I don't know that that's an appropriate expense for these individuals to require. Maybe they should be required to provide the translator so that the entire remainder of the community understands. But that would be my suggestion of a potential resolution. That's more of a mediator answer than a lawyer answer, but it might work.
Okay. Let's go to Ray, and I hope I'm pronouncing this town right. Lutz wants to know what happens if we are unable to get our milestone inspection completed. We have called numerous companies, and they are all unable to schedule another inspection. I knew this would happen.
So was that you saying you knew this would happen, Steve, or them saying they knew this would happen?
No, I'm saying I knew, because there's not enough out there.
We all know that there are not enough companies, not enough individuals to do all these milestone inspections within the next year and a half. I mean, we were
and we're early
with Castle Management just the other day. I was covering for my partner Jeff Rembaum because he was had some personal stuff to take care of, but that was one of the main issues that we were talking about, because they had the head of an engineering company on, and they were saying, listen, I'm already scheduling these things out in October. And it's, this was, if you call me today, you might get October. If not, we're starting November. I can understand having difficulty finding someone, especially finding someone that's not going to charge you to drive from South Florida to Tampa or to Orlando or vice versa, to be willing to do this. And frankly, the only thing I can suggest for now, and I say for now, I'll clarify about later in a minute, for now, just keep a record of everyone that you've reached out to that said they can't do it. And you know, if you can get them to email you back and say, sorry, I'm not available, even better. If not, at least keep a record of, I called this company on this date, they said they couldn't get me in. I called this company on this date, they said they couldn't get me in. The other thing I would do is don't treat I can't get you in until 2024 as a no. Set that up. Set it up now. Okay, so, and if you find that there is literally nobody in the entire country or wherever, I mean, you know, you might get an engineer that's licensed here but lives in Zimbabwe for all I care. You know, you try and get someone in. If you're not able to do it, then you can make a request when the actual deadline is approaching with the local enforcement agency, and they might grant you an extension of time to get this done. The reason that I'm saying keep the records is because we have no idea how generous those local enforcement agencies are going to be. And that could be, you know, the building department of Hillsborough County or Pasco County. I don't know who it's going to be as of right now for every particular municipality. But if you can show them, this is the list of 75 companies that I reached out to. They all said they couldn't get me in within the right amount of time. This is one that I found that said they can do it 6 months after the deadline. We just need an extension to get this done. Can we please have the extension? I think you're much more likely to have that granted versus we couldn't find someone to do it. Can you give us more time? Which is what most people come to you saying, and you say that wasn't good enough. So think about if you wouldn't accept an excuse from one of your homeowners, don't expect a government entity to accept it from you.
Wow, this might turn out to be a mess, but it's got to be done.
I think that is a very positive approach to take, that it might be a mess. I think it is and will continue to be a mess unless and until the legislature cleans it up a little further. But you know what? At this point, the only thing that these communities and their attorneys can do and their managers can do is try and keep directing them on the right path to get this stuff done as soon as possible. Because that year and a half that you've got left is going to go really quick.
Good response. Here's Harold in Tampa. We have finished our 40-year on structure, but have not passed the electrical yet. We have 442 units, and there are 30 units that have not had inspections in the units. Is that a question?
I didn't really hear a question.
Yeah.
It sounds like they're trying to ask, what should we do with
what should we do? Yes.
30, you know, all you can do is try and get those other 30 inspected. I mean, the question becomes, what happens when people simply won't let you in the unit? If you're in a condo, which it sounds like you are based on the fact that you're asking the question, you've got the right to technically give notice or just enter into the unit at reasonable hours to do that inspection under the Florida statutes. If people actively keep you from getting in, you know, they block the door or they just refuse to let you in, you might have to file an action seeking an injunction that says they're barring our entry. We're going to be found in violation of municipal code and Florida statutes. We need to move forward. I don't think that the urgency is there yet because some of these things are not yet due. But, you know, you might get into a situation where, you know, you're risking, and I'm dealing with one of these right now in an HOA in a completely different situation, but same potential consequence, that you could be, you know, fined or get a bunch of damages awarded against you by some municipality. And that's certainly not something you want, but it does play into, you know, if you reach out to the local municipality, what are we supposed to do? You know, I didn't hear a question like you said, Steve, but that will give you the answer. What do you want us to do? Are we good to go here with the 30 units that haven't been inspected for the electrical when we've done literally everything else? Or do we really need to, you know, sit here and potentially file 30 lawsuits to try and get a court to say we can enter these units and they can't stop us?
Exactly. Here's Eileen in Seminole. She wants to know, what is Kaufman language?
So Kaufman language is essentially language that would be found in your declaration that says that your governing documents incorporate the statutes that pertain to your type of community. Usually that's going to be either Chapter 720 in an HOA or 718 in a condo, 719 in a co-op. And it's going to say that the declaration usually incorporates the statute. And here comes the Kaufman language as amended from time to time. So your declaration is a contract between your association and all of its members. And that contract is dated and recorded as of the date that it was recorded in the county public records. So usually if there's a change in substantive rights, the Florida and U.S. constitutions won't allow a statute to change those substantive rights. We're talking about your interest in the common elements and common surplus, your ownership of the unit, things like that, the applicable penalties for wrongdoing, things like that. So we're not talking about procedure, but Kaufman language, to give it a very quick answer, is that as amended from time to time language. If you don't have the Kaufman language, those substantive changes to the Florida statutes just might not apply to your community. So and a lot of times, by the way, determining even whether or not something qualifies as Kaufman language is something you should have your attorney do rather than just presuming. Because I've also dealt with a situation about 6 months ago where one attorney said that something wasn't Kaufman language, and in reality, it was pretty clear that it was. So you might want to have your attorney actually give you a legal opinion as to whether those statutory changes are going to apply to your community or not.
Let's go to our phone lines. Let's go to John. Hi, John.
Hello there.
Hi, John.
Can you hear me?
Yeah.
Yes, we can hear you fine.
Oh, yes, I've got a question. I'm the president of a community association in Central Florida, and we've got a new management company took over about the middle of last year, and our reserves line items have changed 3 times in the past 6 to 8 months. In other words, just like our roofing should have, like, let's say $750,000 in it. It doesn't. It's got like $30,000, and then gutters has almost $750,000. And I asked the manager, she says, well, we'll have to look into it and we'll have to vote on it. And I said, somebody messed up. And it's happened 3.
Yeah, I mean, the bottom line, the fact that you're mentioning that it happened 3 times that these amounts changed sounds like they're moving funds from one account to another, which generally requires a member vote for line item reserves. So it sounds like you might want to talk to your management company that might not be doing things the way that they're supposed to, and frankly might get the association in trouble if they're not willing to, put the funds where they belong. And when I say where they belong, I mean pursuant to the budget and pursuant to what they came into. In other words, where were these
Correct.
individual line item funds when they took over? Was the money in item number 1 or item number 2? It should basically, each reserve, each line item should look like starting point given to this management company plus additional funds placed into the reserve pursuant to the budget and actually collected. That's it. Unless the membership had a vote to move the money.
We didn't have a vote, but when I brought it up to their attention, because I just came on board earlier this year when I was voted in. And when I happened to look at it, I brought it to their attention and they just looked at me. And we know the roofing should have $750,000. It was up near that anyways. But see, when they changed it, I don't know what happened. Then it changed again. And the board that we took over from, they all just disappeared. They don't have nothing of what they did or how they did it. Because along with this mess, there's a $500 petty cash account that can't be accounted for. The money just disappeared.
It sounds like
So
you might
when I'm
consider you might consider having an audit performed, both to address what might have happened with management and what might have happened with the prior board. You may not have access to all the records you need, and you may need to go find the prior board within the confines of either a lawsuit or just, figuring out a way to reach out to them. This is something that I've addressed personally in the past, and it is not a fun situation for you to be in, because, the bottom line is you're the one responsible for all this now, even if you didn't cause any of it. But I think that a financial audit is probably going to be your best bet to clean all this up.
Well, I've had a couple of board members, they say, we've got bigger fish to fry. And I says, no, when you're messing around with your financials and they're in a big mess, because we've had 4 management companies in the past 5-6 years. And each time they turned them over, we've got 2-3 years of financials missing within the past 5 years. And we can't even go back to collections because, collecting on the accounts that, the people that are behind, we can't pursue collections because we don't have the paperwork to, subsidize the zero balance.
Well, I mean, one thing that you might do is reach out to all the prior management companies and say, we really need any records that you guys created pertaining to our community.
Okay.
Hey, Alan. Thank you, John, so much for your
Thanks, John.
call.
All right. Thank you.
Alan, we got a few minutes left. Let's go over your classes real quick.
Sure. Well, on the 27th, I know we're meeting up, but Jeff Rembaum's going to be doing his legal update and the new legislation summary at Castle's Rise Up Expo. The next day, the 28th, this Friday, Mike Bender's going to be on Campbell Management's panel covering the glitch bill. This is Senate Bill 154 that we talked about earlier. Inspections, milestone requirements, etc. We don't know exactly what August will look like yet. I'm sure I'll have a class and several others will, but we do know that Emily Gannon on August 8th will be teaching about navigating the FHA, the assistance animals or pets. And all these are things that you can check out our calendar. When I say we'll probably have more, that means go ahead and take a look at our calendar on any given day on our website, kbrlegal.com. Under calendar, it'll show you all of the events we've got coming up. And so hopefully, you can take a look at that. You can also register directly from our website on our calendar for any of the events we have coming up. So we'll hope to see you there. And I know I'll be speaking with you, Steve, next month. I know I'll have a condominium board certification class on the last Tuesday of the month because we did HOA today. But beyond that, I'm sure there's going to be a lot more, but that's what we got officially coming up.
Real quickly, we still have 2 more minutes left. Regarding closed board meetings, if there is no proposed or pending litigation, can the board discuss possible litigation in closed meetings? It seems that anything can be possible.
Well, to some extent, Susan, you're right. I mean, there are a lot of things that could be considered possible litigation. The bottom line is that the board has reason to believe that an owner might in the future sue the association for doing something wrong, or if the association is, frankly, starting the covenant enforcement process and wants an opinion from counsel as to whether something is a violation, whether it's something they should be pursuing, etc. That's the purpose of the attorney-client privilege, and it will be a closed privileged meeting. So yeah, I mean, frankly, most things could end up in litigation. I agree. But most things also are just open to the members. So if it's something that you reasonably think could end up in litigation, that's what needs to be, or in my opinion, should be. I won't say needs to be. That's what should be closed off to the members so that you can have those privileged discussions of what happens if.
Man, we got everybody in today. I can't believe it. That's a first for us. K. Bender Rimbaum, Alan Swartzide, thank you so much.
Thank you,
I'll
Steve.
see you in a couple days.
Yeah, we'll see you Thursday, Steve. Thank you.
For sure. Okay, buddy. Thank you for tuning in, everybody. We will be doing our Orlando show on Thursday at 5 o'clock. So please tune in then. Everybody have a good week. Thank you, Rebel. We'll see you soon.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.